In Richmond, British Columbia, an industrial developer called Montrose Properties had already invested $7.5 million into a warehouse project. They were on the verge of securing a $35 million construction loan to finish the job when the bank froze the funds. The bank pulled the funding because the institution can no longer verify that the developer holds valid title to the land beneath the project. This diagram shows the 3 layers of the Torrens system, the 150-year-old framework for property ownership in Canada. At the base is a government-stamped guarantee. This supports the private deed, which in turn supports the bank mortgage. Under this system, a registered deed is meant to be indefeasible, absolute, and unshakable. Banks rely on this single legal certainty to issue billions of dollars in commercial and residential mortgages across the country. The stability of the entire real estate market depends on that government stamp, acting as a final shield against competing claims. That shield lost its absolute authority in August 2025, inside the British Columbia Supreme Court, with a landmark ruling in Cowichan Tribes versus Canada. The court declared that Aboriginal title exists over roughly 800 acres of highly developed Richmond real estate. This ruling confirms that Cowichan rights legally overlap with land already held by private owners. The Canadian economy relies on single-entity ownership. When 2 separate legal titles overlap on a single property, prime real estate becomes a high-risk asset that banks are unprepared to value. The ruling redefines the legal hierarchy of the land while leaving homeowners in possession of their properties. It changes the priority of ownership without requiring immediate evictions. Returning to the 3D Torrens graphic, a new layer representing Aboriginal title slides into the bottom as a senior interest, legally burdening the private deeds. Sitting at the very base, it destabilizes everything stacked above it. The private deed cracks, and the mortgages built on that deed become precarious. This raises an investigative question. Why does the court place Aboriginal title at the base of the stack, ahead of the Crown's paperwork? This 1859 photograph shows the unceded Cowichan village, Tiluktinis. It provides evidence of a settled community with permanent wooden longhouses and established social structures. A colonial official named Colonel Richard Moody was mandated to protect this specific territory and establish it as a reserve. Instead, he orchestrated a scheme to flip the land to himself and his associates. This history creates a legal chain reaction. Because the property was acquired through fraud, the Crown never legally held title to it. In property law, a government cannot sell an asset it does not own. The court found that those original Crown grants were an unjustified infringement on Cowichan rights. This means the modern deeds built on top of those grants for the last 150 years are defective. The current banking freeze is a direct result of this defect. Financial institutions require clear ownership to secure their interests, and they cannot lend $35 million against legally flawed paperwork. As commercial lending stops across the industrial heartland, construction sites remain frozen. When banks cannot value the land, the capital required to build and maintain these hubs flees the region. To address this liquidity crisis, Premier David Eby announced a $150 million government-backed loan guarantee program. This fund acts as a financial bridge, keeping businesses solvent while the legal system determines how to implement coexistence. This shift does not guarantee a real estate collapse. In most cases, First Nations are seeking economic participation and equity rather than the removal of industry. The Tsawwassen First Nations 2009 Urban Treaty provides a precedent. Recognizing Indigenous jurisdiction there spurred significant commercial and retail development. The Squamish Nation is also building 6,000 housing units at Kitts Point. These projects show that Indigenous title can unlock real estate value through partnership. The Cowichan ruling forced the real estate market to abandon a 150-year-old bad faith foundation. Adapting to this new reality means moving from litigation to negotiation, where clear title is secured through equity partnerships and constitutional recognition.